nor cruel and unusual punishments inflicted. However, the Constitution doesn't explain what constitutes a cruel or unusual punishment. As a result, courts have long debated its intended meaning. One view is that of constitutional originalists, who believe that the state of the country when the Constitution was written should be its guiding principle. This would mean that anything acceptable in 1790 would be constitutional, including things like public flogging, being dunked in water, and even child slavery. More realistically, the Supreme Court tends to use evolving standards of decency based on public opinion. This is established by how state judges and juries around the country tend to rule. For example, in 1977, the Supreme Court decided that giving the death penalty in rape cases was unconstitutional based on the fact that only one state allowed that punishment. The Eighth Amendment has also been applied to the treatment of prisoners with a 1992 ruling prohibiting unnecessary and wanton infliction of pain. While police may argue that the 80,000-volt handcuffs will be used humanely, in their short period of availability, they have already been abused. In a 2014 court trial, a judge ordered his bailiff to shock a prisoner with high-voltage leg cuffs in order to stop him from talking. The judge was soon after removed from the bench, ostensibly for this cruel and unreasonable order. In 1972, Justice William Brennan laid out 4 guiding principles for narrowing down the criteria of cruel and unusual. First and foremost, the punishment must not, by its severity, be degrading to human dignity, which primarily relates to torture. The punishment must also not be obviously inflicted in a wholly arbitrary fashion, nor can a punishment be clearly and totally rejected throughout society. Finally, it cannot be patently unnecessary. Although these guidelines are slightly less ambiguous, they still leave the full weight of the punishment on the court's judgment.